For a lot of my clients, they ask me what happens to their estate plan if they decide to move. And that is a great question. So I'm only licensed in the state of Georgia. I could get reciprocity in North Carolina, Tennessee, or Alabama pretty easily. Florida and South Carolina, I would have to take another bar exam. Hard pass on that. I don't want to take another bar exam. And it's just annoying because I'm in Georgia. I'm not even a snowbird. Let me in. But that being said, if they move to another state, most likely they do need to be connected to an estate planning attorney in that state. So I have colleagues all over the place. So I usually have colleagues that I can refer them to. Here's why. With an estate plan, if you have a will-based plan, your will is state specific. So if you move to another state and you do not update your will, then what's going to happen after you pass away is that your family is going to have to probate in the state that you live in, that you passed away in, and then they're going to have to open an ancillary probate in whatever state your will's from. That doesn't sound like fun. So instead of one court process, now they're going to have to deal with two court processes, which is what happens if you own property in multiple states too. So always very important, especially if we are relying on your will, that your will remains updated to whatever your state is for permanent residency. Now, if you have a living trust, the living trust makes this a little bit easier. Shocker, living trusts make a lot of things easier. But a living trust it doesn't really matter where you live. So even if you have a Georgia trust and then you move out to California, it's fine. It can remain governed under Georgia law. So that makes it a lot easier on my clients if they are thinking about moving or retiring down to Florida or South Carolina or wherever, that a living trust doesn't have to be updated. Now, some of the other documents, like the pour-over will for a living trust, those need to be updated. However, again, if your living trust is set up properly, that will is never going to be needed, so maybe not. But the other one is incapacity documents. So in Georgia, we have state documents. They were created by the legislature, which is why they're written so poorly and so confusingly. I didn't write them, I promise, it wasn't me. A lot of states have state documents. So if you move to another state, ideally, you would want to have those state power of attorney documents, healthcare power of attorney documents, because that's what those states recognize better. Now, are the Georgia ones still technically legally binding? Yes, but already people don't want to abide by these. So it's really important to actually even update those occasionally anyhow, but especially if you move to a different state. Usually you're going to want the state specific documents for power of attorney, healthcare power of attorney, because every state has slightly different requirements when it comes to witnesses, notaries, sign. Every state's going to be a little bit different. So if you do move to a different state, those documents you're usually going to want to update. The trust can remain governed. However, if you're pretty young and you think there might be amendments down the road and things will be changing down the road, probably you'll have it restated to a new attorney within that state as well. So that attorney can now continue that relationship of updating it down the road. So trusts are great. They don't automatically have to be updated when you move states. If you have a will, it does. It has to be updated to your new state when you move. Incapacity documents, really important to update those as well.